Yes, sir.
So a mobile cleaner that's using a closed loop system and they're recollecting the water, when they're actually re-cleaning with that same water on another property, what you're saying is they're cross-contaminating contaminants from one property to another property.
What type of cleaning are you doing?
Pressure washing.
And your lots or what? Like parking lots or what kind of pressure washing?
They collect this water, they clean it, and they reuse it. Well, so what you're saying is they've changed much of the molecular structure of the water, so therefore you're saying the water is actually contaminated. And now they take that contaminated water, go to another property, and continue cleaning with the same water, therefore they're cross-contaminated.
Was everybody able to hear that? He's got a closed loop system where they're pressure washing. They reuse that water, I guess, as many times as you can, right? Until it can't be used anymore to get the effect that you want. And I guess the question is, after that first time where everybody's going to agree you've got some contamination there because you just cleaned a job site, but now you want to go to the next site and reuse that same water if you can, right? And clean that site. Is that cross-contamination that I guess would constitute pollution would be your question. And I would say unless you're discharging that water, the answer would be no, at least not for criminal purposes. I mean, we would be okay with that. We would not prosecute a case for that as long as ultimately when that wastewater in your closed loop system can no longer be used, you're manifesting it and taking it to a proper disposal facility and then discharging that water. It's going to be very concentrated, obviously, at that point with probably cleansers, degreasers, or whatever you use, plus whatever dirts and substances were picked up from the cleaning process. But no, just reusing your water over and over to clean up, to clean different sites, to me wouldn't be a problem because you're not discharging it into or adjacent.
So it's okay if I went clean the parking garage and then just came over to your house and cleaned your driveway for you?
Well, I may not like that as a customer, but I don't think you're necessarily committing a crime. You might not get my business again after that because we prosecuted parking garage cases, and I can tell you that there's some really nasty stuff that comes out of those. And I would be really surprised if you could ever reuse that water again after you did that. And again, depending on the type of business that you do, if you have that type of system, I guess you have to decide how often you can continue to reuse that water until it needs to be changed out. Because obviously your ultimate goal is, you want to make money, but you want to make your customers happy, right? So that they call you back the next time. So you have to kind of use your judgment on that. And here's what we mean by discharge, because we have to prove a discharge, obviously, for water pollution. And the key here is that you look at allowed to seek or otherwise release or dispose of, or you allow, permit, or suffer any of these acts or omissions. In other words, a discharge continues to discharge until you clean it up. If you had a discharge a week earlier of some type of waste or pollutant, and you just allowed it to continue for a week or 2 weeks or however long before it's discovered, every day that contaminant has been on the ground, it has been discharging. And so that the discharge is a continuous type of offense, and it's, again, a very broad definition, but we do have to prove some type of discharge into or adjacent to water in the state to prove the offense of water pollution. Now we're going to go to 7.145 of the Water Code. These are where the criminal offenses are. And 7.145 is an intentional or knowing unauthorized discharge. Obviously, we have to prove culpability here, just like if this were under the federal Clean Water Act, where they have to prove culpability of intent or knowledge. And basically, I've just kind of taken that section and broken it down into these 7 elements, because if I go to trial in one of these cases, this is what I have to prove. First, a person intentionally or knowingly with respect to their conduct discharges or allows the discharge of any waste or pollutant into or adjacent to water in the state that causes or threatens to cause water pollution. And then number 7, basically, unless you have authorization of some type for that discharge. You have a permit, and even if you have a permit, if you're in violation of your permit, we can still charge you with a criminal offense for violating that permit. But generally, you have to have some type of authorization, and I would say 99% of all the cases we prosecute, there is zero authorization to do what our defendant is doing. Okay? So let's talk about those for a minute. Now, by a person, obviously, all the individuals in this room are persons, but who else are persons for the purpose of criminal charges? Corporations, associations, partnerships, any type of business entity, as long as it's not a sole proprietorship. If it's a sole proprietorship that you have as your business, that you're the owner of that business, if there's a charge, you're the one that's going to get charged. Because a sole proprietorship in and of itself is an assumed name that you use for your business, but it's not a legal entity, because under Texas law, to be an association and be a legal entity, there has to be 2 or more persons. Okay, so if you're a sole proprietorship, then you would be the one that would get charged with that offense. But any other types of business entities where there are at least 2 people involved, including corporations, and that could be limited liability corporations, limited partnerships, any other type of legal business entity is fair game. And I would say that probably 50% of all the cases we charge are probably against legal entities. Okay, and they carry their own penalty ranges, as you'll see in a moment. The culpable mental state of intentional or knowing. The key phrase here is what you see underlined with respect to conduct. What that means is I only have to show, if I go to trial on a case, that you intended to commit the discharge, or you knew you were discharging. I don't have to prove that you intended to cause pollution, or that you knew you were causing pollution. I only have to prove that you intended to cause the discharge, or knew about the discharge that ultimately caused or threatened to cause pollution. And that's another significant difference from federal law. Under federal law, that culpable mental state applies to each and every element of the offense. Not so under state law. Okay? Discharges allows the discharge of waste and pollutant we talked about into or adjacent to water in the state. What do we mean by adjacent to? The legislature doesn't define that term, but if you look in a dictionary, the dictionary definition of adjacent to is close to or nearby. Well, what constitutes close to or nearby? Generally, that's going to be up to the jury or judge to determine if the discharge in your case, let's say, is adjacent to, assuming that it doesn't make its way actually into the water. And then, of course, causing or threatening to cause water pollution. We are always going to have samples in one of these cases. We're going to have lab analysis, and we're going to be able to show a jury or a judge what's in this discharge. Whether it's petroleum hydrocarbons, whether it's a hazardous waste, whether it's metals, whether it's over your permit for total suspended solids, chemical oxygen demand, biological oxygen demand. Depending on what we know the nature of the discharge to be, those are the parameters that we're going to have the lab analyze for us. And if there's something that's not supposed to be there that gets into the water, then generally that's going to have caused water pollution, or certainly would be a threat to cause water pollution. And then, of course, that last one, generally there's no authorization at all. And if there is authorization, if you have a permit of some sort, you're going to have certain parameters set out in your permit that you cannot exceed. And we will file charges if you do exceed those parameters. So just because you have design of their wash bays or their system that the wash water was leaving and going out into the parking lots. And I don't mean just a little bit, I mean significant quantities of detergents, chemicals, and wastewater that was just rushing into the storm drain on the property. And this person had been warned about this once before, did not correct the problem, and now he is facing criminal charges in court, and he is charged individually because he was operating as a sole proprietorship business. So just keep that in mind, that there's all different types of water pollution and all of those different industries. All right, here's the second way. Yes, sir. You go back.
Just out of curiosity, what kind of monetary damages?
Well, it really depends. A lot of times we'll look at maybe cost of cleanup, if in fact there was cleanup. We're going to look at the size of the business. I can generally get financials on just about any business in the state of Texas, and we usually will adjust our penalties accordingly. And they're different for every industry and every business. I mean, you wouldn't find a small company, a mom and pop company, the same as you would an Exxon. Let's say, although I know a lot of people think that if you're an Exxon, it should be the same, but obviously it can't be because you're looking at deterrence, basically. If you get involved in a criminal offense and your corporation, let's say, is indicted or otherwise charged, we're hopefully going to assess a monetary fine that will deter you from ever having that problem occur again. And if I see you back, then obviously I didn't fine you enough the first time, but I certainly will the second time.